Please start. We've gone live.
Good evening. I'm Shahrukh Alam, and it's my pleasure today to welcome Justice Rekha Sharma and Justice Usha Mehra and all of you to this session. We've got two former justices who've also served on the Constitutional Court, and we thought it might be a good occasion today, in their presence, to do a brief remembrance first for Justice Ruth Bader Ginsburg of the US Supreme Court. She was only the second woman to have served on the US Supreme Court, but we know her as a feminist icon. But she was more than that. During her time, while she worked at the American Civil Liberties Union, the ACLU, while she was a lawyer, and then during her time on the bench, she created a very formidable equal opportunities jurisprudence and equal protection under the law jurisprudence. She was someone who believed in inclusiveness and in inequality before the law. I was struck by some of the things that I read about her and that she has written herself after her passing. But there was one sentence that was said in her honor by a rabbi just before her funeral. And the rabbi said that justice does not arrive like a lightning bolt, but rather through dogged persistence. And it stayed with me, this thought, because from what I've read of her work, Justice Ginsburg also believed that justice is not based in one person. It's not based in one event. It doesn't happen in a vacuum. It's a continuum. It's a continuous process of striving towards something. She believed that it was intergenerational. It was sort of carried on across generations of women and across generations of marginalized communities. So the work of justice, the work of law, was carried across generations. And in her honor today, Mrinalini and I have chosen 3 clips that we wanted to share with you. The first has nothing to do with Justice Ginsburg, nothing directly. But we were very struck by it. It just happened that we came across this fascinating series on Hotstar. It's called John Adams, and it's based on the second president of the United States. But John Adams was also someone who was very active during the Colonial Congress, the Congress of the 13 colonies of the US that were negotiating with Britain for their independence. And he was also very active in the Declaration of Independence. So the series is about him, but it's also about other people on the margins who were not there in the forefront, but without whom he could not have done what he did. And one amongst them was his wife. So we have for you a clip here for discussion, not for commercial use, which is a short conversation between his wife and him. He's just returned from a continental congress where the men, it's full of men, are still debating whether to actually declare independence or not. They're saying, maybe let's just wait and watch how things go. So he's come back and he's telling his wife this. And the wife is being impatient. And listen to what she has to say.
Will General Howe attack again?
It's impossible to say.
Will General Howe attack again?
It's impossible to say.
What is that but an army of occupation? And the Congress goes on its knees to the king. Has the king deigned to reply? I understand people like Mr. Dickinson and his friends all too well, John. Send a woman to the Congress. She might knock some sense into them.
This is not a question of men and women, Abigail. It is a matter of politics.
Politics. Politics? And do women not live politics, John Adams? When I go to the cupboard and I find no coffee, no sugar, no pins, no meat, am I not living politics?
Do women not live politics, John Adams, she said. I thought that was very, very powerful and very perceptive. She said, when I go to the cupboard and when there's no milk and when there's no meat, is that not politics? And I think that was also Justice Ginsburg politics. She believed that everyone lived justice and everyone lived politics and everyone had a stake in constitutional justice, whether you're on the margins or whether you're in the centrality of things. And I think that this speaks also to us. Uh, Sorry, Mrinalini, you're about to start the second clip, but I'll just finish quickly. I think this particular clip also speaks to our context and some of the issues that are before us in our country now. One amongst them is the question of representation. Who gets to represent? What voices get represented in a court of law, in the legislature, outside? For instance, there is the question of criminal law reforms that are going on. And around them is the question of representation. Who is deciding what reforms are good? Which voices are being heard? This is the first clip. Going on to the second, before you start, Mrinalini, I just want to say that one other thing that Justice Ginsburg was famous for, infamous for, were her dissents, her very aggressive dissents on the bench. And when you watch this particular clip, it's very interesting because I've always looked at her as, and she herself considered herself as someone who was quite the outsider. In her interviews and in this particular clip, you'll see that even as a sitting judge, she has this slightly amused, mocking stance even of the court. She's the outside observer. She's on the right side of history, but on the wrong side of the current majority. Let's hear her.
You became quite famous for your dissents. There's been a long period of time where you're the most senior of the four more liberal members of the court. There was a time, I think about 10 or 11 years ago, when Linda Greenhouse of the New York Times wrote an article on the front page of the New York Times where she said that that term will be remembered as when you found your voice. And I think it was probably either the Ledbetter case or maybe the VMI case. But explain, and a bench dissent is when a justice of the Supreme Court actually reads from the dissent, when the court is announcing its decision.
A summary.
From some of it. When you do that, who is your audience? Obviously, the majority already disagreed with you. Are you speaking to the future? Are you speaking to Congress? Are you assuming that, like the great dissents of Justices Holmes and Brandeis, that the day will come when your dissent will be the law of the land? What leads you to want to read a dissent like that?
And by act, which is the soul of simplicity. It simply said, a Goodrich knows, every woman of a certain age knows what she experienced. That is, she was an area manager at a Goodrich tire plant. She, when she was hired, was the only woman area manager. One day, when she'd been working there over a dozen years, someone put a slip of paper in her mailbox. It had a series of numbers. The numbers were the salaries of all of the area managers. And Lily could see that the young man she had recently trained was earning more money than she was. So she said, enough, I'm going to sue. She got a substantial jury verdict, and then when her case came to the court, they said she sued too late. Title VII says you must complain within 180 days of the discriminatory incident. Lily Ledbetter is way out of time. She waited years to sue. My theory was that every time she got a paycheck, the paycheck incorporated the discrimination, so she could sue 180 days from any paycheck. I also pointed out that what would have happened had Lily Ledbetter sued early on. No doubt the defense would have been, it has nothing to do with Lily being a woman. She just doesn't do the job as well. But then she works there year after year and she gets good performance ratings. That defense is no longer available. They can't say she doesn't do the job as well as the men when they rated her as high. But then she works there year after year and she gets good performance ratings. That defense is no longer available. They can't say she doesn't do the job as well as the men when they rated her as high or higher than the men. So now she has a winning case. But the court said she waited too long. So that kind of dissent, if the court is interpreting a statute like Title VII, then Congress can fix it. But when the court is making a ruling on a constitutional matter, Congress can't fix it. Only an amendment to the Constitution, and we have a Constitution that's powerfully hard to amend, or the court has to change its mind. But there has been a tradition in the United States of dissents becoming the law of the land. And we can go back to the worst decision the Supreme Court ever made. It was in the Dred Scott case. There was a fine dissent by Justice Curtis in that case. Or the first Justice, John Marshall Harlan, who dissented in the so-called civil rights cases in 1886 and in Plessy against Ferguson. Or you mentioned Holmes and Brandeis around the time of World War I. Those free speech cases today are all the law of the land. So you're writing for a future age, and your hope is that with time, the court will see it the way you do.
I found this particular clip also very, very inspiring. She's speaking like an outsider. She's speaking like a young civil rights lawyer, not like a sitting judge. One of the most famous dissents was in the Bush versus Gore case of 2000, which was about whether there should be a recount or not after the elections. And she wrote two words in her dissent. She said, "I dissent." And that was her dissent. 5:4 minority. And that was, I think, one of the most powerful dissents. Had she written hundreds of pages, it could still not have been as polemical, as rhetorical as this was. But leaving that behind, I just want to also mention very quickly the three references that she's made in this interview when she's talking about dissents, powerful dissents that later went on and became the law of the land. She refers to the Dred Scott case, which she says was perhaps one of the poorest decisions of the US constitutional case, US Constitutional Court. And that was about, the question there was whether the constitutional guarantees should also be available to Black Americans or not. And the majority said no, that the constitutional guarantees in the US Constitution should not be made available to Black Americans. They were only meant for whites. And Justice Curtis had dissented, which is what she is referring to. So her philosophy of inclusion. The second case that she's referring to is the segregation case, where John Marshall Harlan had dissented. and said that separate but equal is not good enough. The majority had said that segregation is okay as long as there is some kind of equality between the facilities given to Black Americans and to whites. The minority had said not okay, which later went on to become the law in Brown's case. And the third case that she's referring to here is the World War I case, where there were 5 Russian men in the US. And during the World War I, they had written pamphlets supporting Russia, even against the US, against the country that they were resident in. So of course they were all arrested and charged with sedition. And Justice Oliver Wendell Holmes had written his dissent, saying that they had every right to do that. There's no problem, even if they're supporting Russia against their own country, even during a war situation. It was a dissent then, but it became land of the law, or it was reaffirmed after the First Amendment principles in the US. The last clip now, and we'll finish this session after that. Please, Mrinal.
Well, I would say that we are not experiencing the best of times. But there's hope in seeing how the public is reacting to it. The Women's March, I've never seen such a demonstration, both the numbers and the rapport of the people in that crowd. There was no violence. It was orderly. So yes, we are not experiencing the best of times, but there's reason to hope that we will see a better day.
What is it about the current climate that most concerns you?
Our legislature, which is the first branch of government, is right now not functioning. But I can think back to 1993, the year that President Clinton nominated me for a vacancy on the Supreme Court. I had spent 10 years of my life litigating gender discrimination cases. I was one of 4 general counsel to the American Civil Liberties Union. And yet, the vote to confirm me was 96-3. No one raised a question about my affiliation with the American Civil Liberties Union. That kind of rapport doesn't exist now. But my dream is that we will get back to it.
And on that note, we'll finish this session, and I hand over the floor to Shivani Luthra Lohia, who's a practicing advocate in New Delhi. She graduated from Amity Law School, Delhi, and then went on to do an LLM from the University of Pennsylvania Law School, and also an MPhil in criminology from the University of Cambridge. Ms. Lohia has had an independent practice since 2018 and has recently started a chamber by the name of Law Chambers of Saluja and Luthra Lohia. Ms. Lohia has a keen interest in criminal law, commercial litigation, and arbitration, along with other allied laws. Over to you, Shivani.
Good evening. Thank you, Shahrukh, for the introduction. It's an honor moderating today's webinar. I would like to welcome our esteemed speakers and everyone who has joined the webinar. I would like to start with an introduction of Justice Rekha Sharma. Justice Rekha Sharma was born on 31st July 1949. She passed out from St. Thomas Higher Secondary School, New Delhi, and thereafter she did her graduation from Miranda House, University of Delhi. She did her LLB from the Faculty of Law, Delhi, and was enrolled as an advocate in the Delhi Bar Council in 1972. She's practiced mainly in the High Court of Delhi on constitutional, civil, and criminal matters, and was appointed as the Central Government Counsel for the High Court of Delhi in 1977. She continued to be the Central Government Consultant for more than a decade, till 1988. She was selected as an additional district judge in January 1988 and was appointed as the District and Sessions Judge with effect from 1st October 2004 till 23rd February 2005, and became a permanent judge on 22nd February 2006. She retired on 30th July 2011. I would like to hand the floor over to Justice Rekha Sharma, whereafter I will introduce Justice Usha Mehra before her speech.
Hello? Hello, can you people hear me?
Yes, ma'am, we can hear you.
So can I start now?
Yes, ma'am, please.
All right. So Honorable Justice Usha Mehra, the moderators and my friends, good evening to you all. I feel it is my proud privilege to be talking to you today. Though social distancing is a bit of a damper, but then we have to make best of the circumstances that we find ourselves into. I have been asked to speak on my journey in law, or if I may put it, my journey from a lawyer to a judge. I am reminded of an Urdu couplet before I start. मुझे तो होश नहीं, आप मशवरा दीजिए. मुझे तो होश नहीं, आप मशवरा दीजिए. कहाँ से छेड़ूं फसाना, कहाँ तमाम करूं. My journey has been long, arduous, and full of challenges. I do not come from a family of lawyers and judges. So after I finished my law, I was to find a senior. I was totally at sea with myself. I didn't know how to go about it, whom to contact. I just could not walk into anybody's chamber and request that I may be taken as a junior. Luckily for me, my cousin had a friend who knew a senior advocate who was practicing both in Supreme Court and in High Court. She is no more. God bless her soul. She was a wonderful person, very accommodating, and very affectionate too. But she had one drawback. She would never make it to the court in time. And this cost me very dearly on my very first brush with the court. I was just 2 days old in her chamber. Her chamber was in the Supreme Court. When she came rushing to the chamber and handed over a cause list to me with the instructions that I have to go to the courtroom of the Chief Justice of India in the Supreme Court, and I'm supposed to mention a matter on her behalf, telling the judges that her mother-in-law had fallen from the stairs and she would not be able to do the matter. So that was the first time ever in my life that I had entered a courtroom. The sheer size of the courtroom and the judges sitting on a pedestal was enough to unnerve me. And top of it, I saw lawyers vying with each other to mention their matter first. I could not muster the courage to mention the matter until everybody else had finished. When everyone had finished, then I moved forward, and like a parrot, I repeated what I was told to tell the judges. I said, my senior's mother-in-law had fallen from the stairs, so this matter may kindly be adjourned. The judges looked at me and they said, what item are you mentioning? I said, item number so and so. They looked into their cause list and again at me. They said, what is the name of the case? Then I gave them the name of the case. Then they again looked at me and they looked at the cause list. They said, what is the number of the case? Police. So I gave them the, can you hear me? Hello?
You can be heard, ma'am, loud and clear.
So I gave them the number of the case. By then, the judges were totally confused. And I think they were very exasperated also. They asked the courtmaster to take the cause list from our hands. So the courtmaster took the cause list from my hand and gave it to the judges. They looked into the cause list, and the Chief Justice then looked at me and told me, young lady, you are holding in your hand yesterday's cause list. And for all you know, your matter might have been dismissed already. I didn't know where to look. I was feeling so small, so embarrassed. So quietly I was leaving the courtroom and all the time feeling as if everyone is looking at me only. So when I came to the chamber, I told my senior, I said, आपने मेरे को कल की cause list दे दी. Her reaction was shocking. She said, अच्छा कल की cause list थी. चलो कोई बात नहीं, मैं पता कराती हूँ कि केस का क्या हुआ. I said, what about me? I felt so small. She said, look, if you want to be an advocate and want to practice in court, you better be thick-skinned. This is not the first time that you are faced this embarrassing situation. There will be many more situations. And you better shake it off as and when you are faced with such a situation. I couldn't say anything more, so I kept quiet. As I said, my senior had good practice both in Supreme Court and in High Court. And in Supreme Court, she had a lot of private briefs, and in High Court, she was a central government counsel. So she naturally gave more preference to her private work. And so most of the time, I was sent to High Court for taking adjournments on her behalf. Day after day after day, High Court in those days used to be in Patiala House. I was only taking adjournments on her behalf. And a situation came when I almost came to be known as an adjournment expert, which was quite derogatory. So one day I told my senior, I said, enough is enough. I'm not going to appear in High Court anymore unless you give me the files in advance, so that if I am asked to argue the matter, I can go ahead with it. She was a little taken aback by my this upfront statement. But willy-nilly she agreed. So with the result that thereafter, I started not only appearing for taking adjournments, but also started arguing cases. So I was able to find my feet and my lost confidence also. There was, of course, the problem of logistics. See how to move about from Supreme Court to Patiala House Court. In those days, seniors never used to pay any stipend to their juniors because they thought that the mere fact that they have taken us as juniors was a big favor. And I had neither finances nor conveyance to travel from Supreme Court to Patiala House. So this distance for many years, rain, hail or storm, I covered by foot with the number of files. Sometimes those files were heavier than my own weight and with a gown on my shoulders. Anyway, but I think that exposure which I got during this period held me in good stead in my further future professional career. Then something strange happened. I'll take you back to 1975 when Srimati Gandhi had imposed emergency. And all the political leaders, including the bar leaders, were taken into custody. I'm sure all of you must have heard about Mr. P.N. Lekhi. His son is now a leading senior advocate. So Mr. Lekhi was a very vocal critic of Mrs. Gandhi. So he too was taken into custody. The only way the family of those detainees to meet them was by coming to the court as and when the detainees were produced in the court. So one day I saw Mrs. Lekhi coming out of the auto. With one hand she was holding a tiffin, and in the other hand a thermos and some files under her shoulders. And she looked very sad. I went up to her and I asked her, "Can I help you?" She looked at me and she said, "तुमको डर नहीं लगता?" तो मैंने बोला, "किस बात का डर?" She said, "आजकल तो लोग हमें देख के ही मुंह फेर लेते हैं." I said, "ऐसा कुछ नहीं है." Anyway, I escorted her to the bathroom where she was supposed to wait for her husband. And that was the first and the last time I ever talked to her. In 1977, the emergency was lifted. And as a matter of policy, the Janata government decided to scrap the government panel which was there during Mrs. Gandhi's regime. So a new panel was to be prepared. In the meanwhile, the High Court had shifted to Sheshasuri Marg. I was just standing on the second floor when Mr. Lekhi came to me and he said, "तुमको गवर्नमेंट काउंसिल बनना है?" तो मैंने बोला, "बन जाएंगे." तो उन्होंने बोला, "ठीक है, tomorrow morning you go to the litigation section of the law ministry, which in those days used to be in the basement of the High Court, and collect your appointment letter." So I went there and I got my appointment letter. I was thrilled because I had hardly put in 4 to 5 years of practice and I had got this appointment, which I felt was a big achievement. But I am still not able to unravel this mystery as to who recommended my inclusion in the panel. Whether it was the benign hand of the Providence, or was it that Mrs. Lekhi had put in a good word about me to Mr. Lekhi, or was it my hard work in the High Court? But anyway, let's leave it at that. But this was not the end of my ordeal. You see what happened, that the government had issued a notification saying that all those government cases which were earlier being dealt with by my seniors, they were all transferred to me lock, stock and barrel. So the files were about 250. So all the government officers who earlier used to brief my senior, they started briefing me. And as I was continuing to operate from her office, she one day told me, look, it is very embarrassing for me that the same people till yesterday were briefing me and are now briefing you. You please leave my chamber and make your own arrangement. So again, I neither had an office nor the finances to rent an office. So I shifted all the files to my residence and operated from there till I was allotted a chamber in the High Court. I felt that first as a junior of my senior and then in my own capacity, I had done very well for my standing and age in that profession. And let me confess, I always wanted to be a judge. But I also was very conscious of the fact that nobody is going to send me to the bench from the bar straight away. So I thought that I should try my luck to become an additional district judge first. And Justice Mehra was an inspiration in that regard because she had joined as additional district judge much earlier than me. So when the vacancies were declared, I also applied and went for the interview, which was to be held by 5 senior most judges of the High Court. When I entered the room, the judges told me, "Why have you come? We don't need to interview you. We know you. You please go." Though you may find it strange, but this is a fact that I was appointed an additional district judge without any interview. So now when I went to the district courts, I found it was a totally different ball game. First of all, I rather, I would say we as a class who had directly gone from the bar to the level of additional district judges were not welcomed by the service judges who were there. They were very resentful of our appointments, and they somehow thought that we were kind of usurpers who have taken away their posts and are sitting over their heads. So they went to Supreme Court claiming seniority over us. We had 3 rounds of litigation and we lost all the 3 rounds. So when I had joined as additional district judge, on the basis of the seniority then, I thought I would make it to the High Court in a period of 10 years. But because I lost the seniority, so it took me 16 years to come to the High Court. But then as they say, it is not the quantity, but the quality that matters. But I am nobody to comment on my quality as a judge. It is for the bar to comment. It's very strange. When we were in district courts as judges, we were treated as outsiders. And when we came to High Court, the judges who were directly appointed to the bench from the bar treated us as promoted judges. So either way, we were not much welcome. So, but whatever. As a judge of Delhi High Court, I decided a number of cases. But there are 2 cases of which I would like to make a special mention. One is about River Jamuna. You see, during the Commonwealth Games, a writ petition was filed by some environmentalist complaining about large-scale construction which was being carried out on the periphery of the Jamuna and on the riverbed itself. At least this was their allegation. So it came before a bench headed by Justice Sikri, and I was the other member of the bench. The government was represented by no less a person than the Attorney General of India, who said that if we halted the construction, then it is going to spell havoc for the Commonwealth Games. It was a national prestige and pride for all Indians that we were hosting those games. And the construction the place where the construction was being carried out, all permissions required from the various authorities had already been taken, and therefore there was no reason to pass any order stopping the construction. We were in a dilemma what to do. The main order was written by Justice Sikri, and we appointed a committee of experts headed by Dr. R.K. Pachauri. And Justice Sikri left it at that. I felt that merely appointing Dr. Pachauri to look into the complaints of the environment was not enough. It was neither here nor there. So I told Justice Sikri that I would like to write my own order. You were talking of dissent just now, so I'm coming to that. So he said, go ahead. So I wrote my own order in which I gave specific directions to the committee that the committee should give its report within 4 months, and a direction and a warning to the government that in case the committee comes to the conclusion that the construction that were being carried out are going to finish the river forever or may have a very serious impact on the ecological system, then we will order dismantling of all those constructions. I must say, to the credit of Justice Sikri, there were many other directions that I passed. We did not go into those details. Justice Sikri agreed with me, and though we had written separate orders, but in a way they were common. So the matter was taken to the Supreme Court, and Supreme Court stayed our order in no time. I felt very sad. I was reminded of 2 lines from Lord Tennyson, which he had written in the context of nature. Men may come and men may go, but I go on forever. I thought one day Yamuna will say, men may come and men may go, but I am gone forever. So environment is a issue which concerns all of us today also, and it concerned us 8 years back also. And I'm sure many people are working on it. Something will come out. The other case which I wish to mention is about air hostesses of Indian Airlines. These air hostesses were supposed to maintain a certain body weight. And if they exceeded that, they were grounded and were to be treated as on leave. And if there was no leave to their credit, they were to be treated as on leave without pay. So some of them had exceeded the body weight prescribed, and they were grounded, so they came to the court. I have a feeling that matter came before me, that their hostesses were very happy that the matter had come before me, I being a lady judge. But I think they were in for a shock. Apart from the legal arguments that they raised, the most vociferous argument that they advanced was that the order was anti-women, gender bias, and reflected misogynist state of mind. I rejected all the arguments. And I felt that there was nothing misogynist about the order, nor was there anything of gender bias in it. It was a part of condition of their service. And they were into hospitality industry, where the nature of their job required to keep their weight within limits. And otherwise also, there could be occasions where the aircraft could develop a snag, or because of air turbulences, there may arise problem. In such situations, the crew is supposed to act very swiftly in emergency conditions. And unless they are physically fit, they cannot perform their duties effectively. I don't know what happened to the matter. In the light of this case, my message to my young friends is this, that they are all educated, hardworking, intelligent. They should rely more on their merit than on this women card. I feel women today are second to none. And they have enough in themselves to stand shoulder to shoulder with their male counterparts. And not only they can become equal to them, but they can even surpass them. Of course, this does not mean that we do not have women in the society who are underprivileged or are victims of atrocities by their in-laws. I feel as lawyers, we need to help them pro bono. Hathras case is one such incident where I feel women folk and women lawyers particularly can contribute a lot. As I started my address with a Urdu couplet, I would like to end also with an Urdu couplet. खुद ही को कर बुलंद इतना कि हर तकदीर से पहले खुदा बंदे से खुद पूछे कि बता तेरी रजा क्या है. Thank you so much for bearing me for half an hour. I wish all the best.
For sharing your inspiring journey in the profession. I would like to mention that we will be taking up questions to the speakers from the audience. So please write the questions on the chat and we'll take up as many questions as time permits.
Shall we hear Justice Mehra first?
Now I would like to introduce Justice Usha Mehra to the audience. Justice Usha Mehra was born on the 14th of November 1951. She got enrolled with the Bar Council of Delhi in December 1962. She was appointed as the panel lawyer for the Northern Railway in 1965 and she remained on that panel till April 1980. She joined the Delhi Higher Judicial Service directly from the bar in April 1980. She worked as the additional district and sessions judge till May 1984 and was the registrar of Delhi High Court from June 1984 to May 1987. He worked as the additional district and sessions judge in charge of the Patiala House courts and was elevated as an additional judge in the High Court of Delhi on the 13th of July 1990. She became a permanent judge on 7th November 1990. Justice Mehra retired on 14 November 2003. And since her retirement, she has been taking up proceedings, arbitration proceedings and giving legal opinion. Ma'am, if I may give the floor to Justice Usha.
Thank you very much for giving me this opportunity to meet all of you and Justice Rekha Sharma after such a long time. Anyway, I belong to a generation when the profession was not considered conducive or good for the ladies. The parents' mindset was that this profession is not meant for ladies. It's a male-dominated profession. And as the luck would have it, I decided to join the profession. No senior was ready to accept. And there were hardly 4 or 5 lady lawyers throughout Delhi, right from Supreme Court to District Court. And I started the practice in Tisari Court, which was the only district court at that time. So somebody introduced me to a very senior lawyer who was practicing on the labor side. I joined him. I found there is a discrimination. He would ask me to study the brief, research, do the research, but will not take me to the court. Whereas a male counterpart, who was also a junior, he would assist him in the court also. And nothing was paid because I was not appearing in the court. Anyway, worked for some time. I realized that it's not worthwhile. When you are not taken to the court, you do not know what is happening in the court. You are simply going to the office, studying the file, searching the books, and come back home. So I decided to start my own. And I, in fact, started on the civil side in Tisari Court. The mindset of the lawyers was the same as of our parents, that these girls have come to the profession to do husband hunting. And when you talk to a male lawyer of your own age, you will have to hear very sarcastic remarks from the old generation lawyers. They would invariably pass remarks, and if you hear it, you wanted to quit the profession and go home. But then, since we were 2 or 3 lady lawyers, we decided to continue and fight back. Fortunately for us, district court judges were very cordial, very helpful, and they would encourage us by giving local commission, by appointing amicus in various matters that encouraged us to remain in the profession. Then with the passage of time, because in 1963, I don't think many of you must have been born, or if born, you must have been a toddler at that time. So in the profession, 2 or 3 lady lawyers who were practicing in Tisdari, we formed a lady lawyer association. A case came, it was in 1966-67, where the district judge handed over the custody of 8 months old child to the husband on the ground that the mother is working, she is in a embassy since morning 8 o'clock to 6 or 7 o'clock in the night. She remains out of the house. The child has been brought up by the grandmother. Therefore, the custody must be given to the grandmother and the husband. I, as the secretary of the association, immediately moved the High Court, saying that the district judge has passed an order against the wishes of the mother and handed over the child 8 months old to the grandmother. The Chief Justice of India, the Chief Justice of Delhi High Court, issued notice to produce the child that very evening. The husband tried to await the process. After lunch, we again went to the Chief Justice and said the process server is not serving the husband and the child has not been produced. So the child was produced. Then the Chief Justice passed an order that service must be effected and help of the police must be taken, brought the husband, grandmother and the child. And that judgment is a reported judgment. Worth hearing, it is just a 1 paragraph. Child custody was restored back to the mother. And the Chief Justice writes that the touch of the mother works like a magic wand on the child. After coming back from the office, when she touches her own son or daughter, it has a different affection, different meaning. Grandmother's touch cannot be the same as of the mother. And the judge who has passed this order was devoid of common sense. This sentence that he was devoid of common sense, the district judge lost his elevation. So this was the atmosphere at that time. We struggle hard as a lawyer, as a lady lawyer, to establish in this field. Because whenever we put a point across, it was in the habit of the lawyers to make comments while we were arguing. So fortunately for us, the district judges were very kind and they would help us. And if we were not ready with everything, they would give us 1 or 2 days time to study again and come back. I remember a case where while conducting the cross-examination, I fumbled. So district judge said, go home, prepare the cross-examination, write down the points which are very necessary to be put to the other side, then come back. Perhaps this sort of encouragement to the junior may not be there now, but it was very much there in our time. Because we were very few lawyers, only 2-3 lady lawyers, so even the bench used to encourage. With the passage of time, I found that hard work, determination, and spirit to fight paid me a long dividends. We did not stop in spite of hearing the sarcastic remarks from the male members. But with the dint of hard work, the law officer of the Northern Railway who had come to attend some case found me argued. He sent for me and appointed me a panel lawyer for the railways. I delivered the results. With the result, I was appointed as the senior lawyer for the railways in due course of time. But one lesson I learned at my own cost as a lawyer, and that is never step into the shoes of the client and never get emotionally attached to the brief. Your job as a lawyer is to only present the facts, interpret the law, and be done with it. This was a case given to me by a lady who had a strained relation with her husband. She delivered a child. He wanted to see the child, but the lady's parents were not prepared to allow him to see the child. He went to an executive magistrate because in 60s, there was no separation of judiciary and executive. They were executive magistrates. He issued the warrant, search warrant. Now the lady and her father used to say that that magistrate is belonging to the same caste as her husband, and they were in connivance with each other. So out of zeal, you can say, or out of getting too much involved in the brief and getting emotional, I filed a revision and wrote that the warrants have been issued because they were in connivance and had loved. That session judge found it is a contempt of court. Anyway, matter was referred to the High Court. I thought now some punishment will be given to me because I have used a wrong language. Anyway, Chief Justice ignored that, and as Rekha says, Mr. P. L. Lekhi was appearing for the husband. He was more insistent that I should be punished for contempt. But the Chief Justice Dua insisted that I want to punish the executive magistrate who has issued search warrant for eight days old child. So anyway, because of that, the Chief Justice did not punish me, but ordered the transfer of the executive magistrate from Delhi. So I say, friends, never get emotional with the brief. Never step into the shoes of your client. Be a lawyer, detached from the client, look into the facts, look into the law, and address the argument. Don't go beyond that. That's my advice to everyone because I learned it at hard way, and that's why I'm telling you people. Subsequently, many lady lawyers joined, and it became a very good place. Delhi didn't have its own high court. It was a circuit bench of the Punjab High Court. And we were in Travancore Cochin House, where the High Court was. Judges were very finicky about the code dress of the lady lawyers. We had a lawyer from Bengal. She was very fond of wearing bangles. She appeared with her senior, and when she gave in the books, the bangles started tingling. The judges got annoyed and said, this is not the way to come to the court. This is not an exhibition ground, this, that, or the other. So at that time, dress code was insisted that lady lawyer must wear black sari, white blouse, white sari, black blouse, but nothing else. Even salwar kameez was at that time not permitted, only saris was there. We were bound by the dress code of the High Court. I also became a standing counsel for the arbitration of the DDA, Delhi Development Authority, and dealt many of their cases. Then, with the passage of time, after having gained experience for 10 years, I shifted to the High Court. When the High Court shifted to Patiala House and thereafter to at the present place. Like I said, everybody has a desire to rise. So I also applied for the post of a district judge. And my name had also been recommended as a additional standing counsel for the income tax. So when the interview took place, the then Chief Justice told the member of the committee that her name has been approved as additional standing counsel income tax on the recommendation of Justice Kirpal. So I was asked, what do you prefer? I said, whichever will come first, I'll prefer that. So I was offered ADJ's post. I took it over. My only request was that I should not be given criminal court because I do not know. I have never practiced on the criminal side. So give me civil. I was given civil side to deal with matrimonial matters. And you know, matrimonial matters give you a lot of heart attacks. When the husband and wife with small children fight in the court as if they are the enemies ever seen anywhere. I had taken for 6 months when a husband filed a petition for divorce. And in order to pressurize the wife, he also moved an application for the custody of the child. Notice was issued. The girl appeared and she laid the child on the table and said, give the child to the husband, and walked out from the court. The husband said, I need time to take the child because I have to arrange for the clothes, I have to arrange for the food, I have to do something. I said, what can I do? Do you ask for the custody? She has given the custody, you take the custody. It continued for some time and then I told the lawyer, you have to take the custody. Now the lady has walked out, what can I do? So I took the custody. I gave the next date, on which day you will be shocked to know. The lawyer told me that the child has been handed over to an orphanage because the husband never wanted to keep the child. It was only pressurized tactics that he wanted the custody. Such cases has a bearing on you and impact your heart and mind. The second case which I as a sitting judge on the matrimonial side found, the husband had 3 children living with his parents. Husband and wife used to fight with each other. They decided to divorce. And after filing the divorce application, he threw her out along with the children from the matrimonial home. She came crying and said, where should I go? I have got 3 children. He should take the children. Then I can go to my parents' house. My parents are poor. They cannot afford me and my 3 children. So I told the husband, why don't you pay her some rent? Why don't you make her some arrangement? He said, nothing doing. I don't have the money. I am not earning anything. I am without job. My parents do not want to keep her. As a judge, I was helpless. I said, I can't help you. I can only grant you the maintenance, provided you prove that he has a source of income. If he doesn't have the source of income, how can I compensate you? But today I am very happy with the judgment of the Supreme Court, which passed yesterday, that the lady has a right to be in the matrimonial home if she had been living there and thrown out by the in-laws. Had it been there, In retrospective, I think I would have done the same thing. But unfortunately, it was not there at that time. And even till this judgment was there, the court could not have forced the lady to go back to the matrimonial home. Then I was transferred from civil court to the criminal court. And in the criminal court, I find when the criminal appears before you, your mindset changes. You feel you are in a very odd place because their narration of facts, the incidents are so horrifying that it becomes difficult to digest that. This case, which I am specifically referring, pertains to a married woman who was pregnant. She was 6-7 months pregnant. She was burnt alive by her husband and in-laws. Girl's mother had gone to her in-laws' house to tell them that at the moment we cannot give you dowry, but at least keep our daughter in a better way. In her presence, the girl was burnt alive. Trial started. Complaint was filed by the mother. She was the eyewitness. I do not know what transpired between the time she made the complaint and between the time her statements was taken. She became hostile. She said nothing happened. My daughter must have committed suicide herself. I wish there had been a law to give protection to the witnesses, which now Supreme Court says should be given, but I feel still at the grassroots level it is not there. But at that time, there was no protection to the witnesses, and they were bought, browbeaten, and threatened, with the result the witnesses will go hostile. And this I felt very bad. A young girl lost life because of the dowry demand and the real mother going hostile. I must say, in 1990, I was elevated to the Delhi High Court. And I find the work in the High Court is totally different, because as a trial court, you come across with the accused, with the petitioner, with the respondent on one-to-one basis. You can form an opinion whether the witness is telling lie or not. But when it comes to the High Court, most of the time appeals are before you, files are before you, and not the person concerned. So forming opinion is quite difficult. I dealt with all sort of cases in High Court, be that original, be that criminal, be that company law, almost all sorts of cases I have dealt. I was given the charge of the criminal court. And the public prosecutor, now the judge of the Delhi High Court, used to appear. A bail matter came where the father wanted that bail be given to his daughter. She should be released on bail. One NGO appeared and said, bail should not be given because these are people from Rajasthan. There is a community, I forgot the name, that the first daughter of that community has to be a prostitute. It's a must. There is a community in Rajasthan, even now. Though we tried our best to call for the panchayats and ask them not to do this, I found all his 7 daughters were in the brothel house. So the public prosecutor suggested that call the commissioner police, form a core committee, raid the GB Road. I don't know whether you people have heard the name GB Road. Is known for brothel house for trafficking. The SHO of that area, in connivance with these madmas, had been allowing them to use for trafficking purposes even 13 years old girls. So I got the GB Road raided by very senior officers and the NGO. Can you beat it? There were 300 girls hidden under and various places in cupboards. They had a hole in the wall where behind it they were hidden. They were recovered. They were subsequently rehabilitated and reunited with their parents. But unfortunate part is we as judges cannot continue monitoring such things. It is a social problem. Article 23 and 24 of the Constitution says that trafficking is, there should be protection, prohibition against trafficking, against child labor. But after having dealt with this case, I realized that the provision of law and the actual thing, what is happening at the grassroots level, are totally different. The protector, that is the police, are themselves involved in trafficking. This is what I found while dealing with that case. And it's still going on or not, I don't know. But what I find that there is a lot of difference between a lawyer and a judge, the work-wise. Lawyer job is over as soon as you address the final arguments. Be done with it. And thereafter start the job of the judge. Decision making, my dear, is not easy. If you are conscious, if you are actually wants to do justice, then you have to work hard. As a judge also, you had worked hard as a lawyer, and that's how you came here. As a judge also, you have to work hard. You have to be sincere to your brief. You have to deliver the judgment not with your conscience, but based on law, based on the facts of the case. Neither we can go beyond the brief, nor we can forget that justice is required, in which principle of natural justice can also be involved. So, as a lawyer, my sincere advice is that they, like in Corona, they say, test, test, test. I say for a successful lawyer, hard work, hard work, hard work is the only thing. Beside the hard work, you have to be sincere to your brief. You have to be sincere to your client. You have to be sincere before the judge. When you are presenting the case, go fully prepared. Don't leave anything for chances. That's the only way you can survive in this profession. Otherwise, from 1963 till date, I say it's still dominated by males. So I wish you all the best in this profession, which is considered to be, I'm very happy. Some of the young lawyers have filed petition in the High Court which has changed the law, which has given a new interpretation to the existing laws. I remember some names of the young lawyers who have filed the petition and got very good orders from the Supreme Court on social justice and for the benefit of the humanity as a whole. Thank you very much.
Thank you. Thank you, Justice Usha Mehra and Justice Sharma, for speaking to us from the heart. It was wonderful listening to both of you. If I may, we have lots of questions from the audience, but since we're running out of time, I thought I'll pick out a few. There are two fun questions and there are some serious questions. So if I may, I wanted to put one fun question, if I may, and one serious question to each of you, and then a fifth one to both of you to answer. So the first question is for Justice Sharma. You'd started by telling us about how your first encounter in the courtroom was one which left you very embarrassed as a lawyer. Then during your time as a judge, did you in turn embarrass other young lawyers? Did that happen?
Frankly,
And I'll just add the serious question as well. That's from Radhika Kuluru. He's asking if percentage-wise, there are more women judges in the lower judiciary than in the High Court and even less so in the Supreme Court. What can we do to help change this? Do you think that the removal of minimum age of 35 years to be appointed ADJ or ASJ will encourage more women to apply to the higher judicial services? Justice Sharma.
Answering your first question first.
Yes, yes.
You see, that was a big time lesson to me. And till date, so many years have gone by and I have not forgotten it. So therefore, when I became a judge, I don't think anybody had any complaint against me that I was trying to bully any judge, any lawyer, or I was rude to anyone. As far as possible, I tried to be very accommodating.
I'm sure.
This is a bit self-serving, but this is how I feel I had acted as a judge. And as regards the second issue, you see, as I said that already there is a resentment amongst the service judges that we people, can you hear me?
Yes.
That we people who go directly from the bar are usurpers. This now it is no longer lucrative to join at the additional district grade level because of the seniority situation. So even if we bring down the age from 35 to say 30, after all, certain experience is definitely required before somebody is taken at the stage of additional district judge. I don't think it would help matters much. So therefore, and not only at the ADJ level, why not at the High Court level also? You find that at the High Court level also, there are far less number of lady judges than the male judges. So, but there are very many lady lawyers who are doing very well. Why can't they be taken, say, at the ratio 50-50? So, I think that people should raise this issue with now that it is initiated at the level of the collegium and then goes to the law ministry. But then at both the levels, it should be taken up and some solution should be found.
Thank you, ma'am. Thank you for that. And now 2 questions for Justice Usha Mehra, please. The first is from Varisha Farasat. She's saying, in your time as a judge, did you generally find that women counsels, on an average, were better prepared than their male counterparts, or was that not the case? And just one other question, if I may add. This is from my co-moderator, Shivani, but I'll go ahead and ask it for her. This is also for Justice Mehra. After the Nirbhaya case in December 2012, the government set up a commission of inquiry to identify lapses and fix the responsibility in the said case. and to also suggest measures to be taken to make Delhi NCR safe for women. The said commission was headed by you. What challenges did you face while heading the said commission, which was set up as a result of an incident that shocked the nation and which led to such widespread protests?
So far as the first question is concerned, I find many of the lady lawyers are, besides being equal, are much better than many of the male lawyers. Those who are appearing before me, out of that, 3 have already become High Court judges. And from the district judges also, before whom I was appearing, have also become High Court judges. So the lady lawyers is not the same age which I faced in my time. Now the lawyers, lady lawyers are fully prepared. They fight properly and they don't give up. That's a good thing because they know they have to compete with the males. So I say they are equal and sometimes better. But so far as Neb's inquiry is concerned, I did not find much difficulty because police of senior rank were placed at my disposal, and whatever inquiry was going on, copies of the same were supplied to me. The police investigation done till date was also supplied to me. So it was not difficult to arrive at the decision. Coupled with the fact, we had some international NGOs who came forward, especially from Australia, that lady came, who gave suggestions as to how to ensure that after the rape is committed, the lady's case is disposed of as quickly as possible. And that's how she suggested that you must have a one-stop center. In that, in a hospital, there should be a separate place where the rape victim is taken. There should be an NGO, a lawyer, a senior police officer of the rank of ACP or SHO, psychologist, and competent doctor, and the nurse who knew what is to be lifted for evidence purposes. Analysis should also be, forensic science should also give the report within a week's time, so that the FIR could be filed within 15-20 days. But unfortunately, this center has not been established so far. Had it been so, the ladies would not have faced a problem from the police, as well as by going to the hospital where everybody is seeing her that she is a rape victim. If they had a one-stop center, it would have been all confidential, and investigation would have done and examination would have done in a very scientific manner.
Thank you for that candid answer. And I think it also connects to the issue of representation, which we had touched upon right in the beginning. When people who are affected by certain things get more of a say in what is happening, then perhaps that question of representation will be sorted. We have time for one final question, which has come from Mrinalini Sen, who's also my co-moderator today. And this question is to both of you, ma'am. She's saying again on the question of representation, what are your views about the recent criminal law committee that has been created, which does not have any women in the panel? Do you think this is something that needs to be remedied?
I think in all panels, lady must be there. That's my view.
Ma'am, and Justice Sharma, what is your view on this?
That this not only requires representation from ladies, but it requires representation from a cross section of the society if you really need meaningful criminal reforms. Then why not a very senior police officer retired is not there? Why don't we have of course, a woman is certainly needed there, and then we need psychologists. There are problems. 3 persons sitting from the legal side alone will not be enough to suggest reforms which are extensively required.
Yes, ma'am. Yes, ma'am. Thank you so very much, ma'am. And on that note, all good things must come to an end.
That's right.
So I have to now offer the vote of thanks to both of you. Thank you, Justice Sharma, and thank you, Justice Usha Mehra, for sharing your stories and wisdom. I would also like to thank Nandita, Soumya, Rinalini, Sunita, Kritika, Suruchi, Aram, and Shivani, of course, for all the work and all the behind-the-scene efforts. A thank you to LiveLaw for streaming and covering the session live. And now also, I'm pleased to announce that the next virtual canteen is on the 30th of October with Ms. Rebecca John, Senior Advocate, and Ms. Sonia Mathur. The session will be moderated by Ms. Anu Narula and Ms. Varisha Farasat. So I'm hoping to see all of you at 5 p.m. on 30th October for another virtual canteen. Thank you. Thank you very much.